Imagine being sentenced to die and knowing there's no one to save you. No appeals, no second chances, just a judge's word, a jury's verdict, and a clock ticking down to your death. This was life on death row in America before 1900, a system built on speed, not truth. In this video, we're diving into the shocking reality of how countless men were executed, sometimes innocent, and how their stories forever changed the justice system. Stay with us, because by the end, you will understand why the past still haunts America's prisons today. Don't forget to subscribe. The rope was already hanging. It swayed slightly above the wooden platform as the crowd fell silent. No phones, no cameras, just hundreds of eyes fixed on one man standing below it. His hands were tied. His sentence was final. There would be no appeal, no new evidence, no second chance. In 19th century America, once the judge spoke the words, death was only days away. The man looked out over the crowd, searching faces that would never help him. Some had come out of fear, others out of curiosity, a few out of hunger for justice or revenge. The prison doors behind him had already closed forever. What happened next could not be undone. And yet, the question that haunted many cases like this remained unanswered. What if they got it wrong? The trap door creaked beneath his feet. The executioner adjusted the rope. Somewhere in the crowd, a woman covered her mouth. Somewhere else, a child watched without understanding what was about to happen. This was justice in America before 1900. Fast, final, and often unforgiving. But this moment did not begin here. It began months earlier, sometimes years earlier, in dark jail cells, in rushed courtrooms, in trials where truth was less important than speed, and in a legal system where appeal was not a right but a rare privilege. And once the sentence was read, there was no turning back. The trap door had not opened yet, but it would. And when it did, history would move on, even if the truth never came out. That is where this story truly begins. In the late 1800s, America was growing fast. Cities expanded, railroads spread across the land, immigrants arrived by the millions. With growth came fear, fear of crime, fear of outsiders, fear of disorder. Lawmakers wanted quick solutions, judges wanted fast sentences, and the public wanted punishment they could see. Death row as we know it today did not exist yet. Prisoners sentenced to die were often held in regular jails or state prisons, sometimes only for weeks before execution. Trials were short, juries were pressured, lawyers were often untrained or absent, and appeals were almost unheard of. If a man was convicted of murder, the sentence was usually death, not after years of review, not after long debates, but swiftly, sometimes within days.
In 1885, in New York, a man named Joseph Molyneux was sentenced in a system that still allowed little room for challenge. Across the country, similar cases filled prison records. In Illinois, Missouri, Georgia, Texas, and Pennsylvania, executions were carried out with little delay and even less scrutiny. Evidence standards were weak, confessions were often forced, witnesses were unreliable, yet the courts moved forward. For poor defendants, especially immigrants and Black Americans, the danger was even greater. Many could not afford lawyers. Some did not even understand the charges against them. Trials were conducted in English, even when the accused barely spoke it. In some cases, juries took less than an hour to decide a man's fate. Once convicted, the condemned was moved to a cell set apart from others. These were not death rows as we imagine today. They were simple cells, cold, bare, quiet. The prisoner waited not for justice, but for time to run out. There were no appeals courts reviewing mistakes, no DNA tests, no investigators reopening files. If new evidence appeared, it often came too late. Governors rarely intervened. Clemency was rare and political. The system believed speed meant strength, but speed also meant silence. Records from the era show men executed even as doubts spread. Some claimed innocence until the final moment. Others broke down, knowing no one would listen. Once the execution date was set, the law treated the case as closed. In 1890, the electric chair was introduced in New York, replacing hanging in some states. It was meant to be more humane, but the change did nothing to slow the process or fix wrongful convictions. It only made executions easier to carry out indoors, away from public eyes. Still, people died without appeal. One case after another vanished into prison ledgers, names forgotten, files closed, families left without answers. And yet, even then, cracks began to show. Journalists started asking questions. Some lawyers spoke out. A few judges quietly worried they have moved too fast. But the system was already built on finality. Once death was chosen, doubt had no place. The condemned man on the platform felt this truth more than anyone. As he waited, memories rushed through him. The trial that lasted only 2 days, the witness who pointed at him without hesitation, the jury that never looked him in the eye, the judge who never paused. No appeal, no delay, no mercy, only punishment. The executioner stepped closer. The crowd leaned in, and somewhere, far from the gallows, the truth remained buried in silence. But not forever, because what America would later discover about death row before 1900 would change everything. And the next chapter begins with a case that should never have ended this way. The cell door slammed shut, and the sound echoed down the stone hallway. Inside the narrow cell, the man sat on a wooden bench, staring at the wall. The date of his execution had already been written in ink, not penciled, not debated. Ink meant final. In 19th century America, once that date was set, the system believed the case was over. But outside that cell, something was wrong. A witness had changed his story. The man inside the cell did not know this yet. He did not know that someone, somewhere, had begun to doubt the truth that sent him to die. And even if he did know, it might not matter, because in this time, doubt did not stop an execution. The clock was already ticking. This chapter begins with a truth that arrived too late. In the late 1900s, appeals were not a normal part of criminal justice. Courts believed trials were enough. Once a jury spoke, the law moved forward without looking back. The idea that a court could be wrong was dangerous to the system, so it was ignored. Many men on death row were convicted on weak evidence. Some were convicted on the word of one person, others on confessions made under pressure. Police methods were harsh, interrogations were long. There were no rules about how far officers could go to get an answer. If a man said he did it, the court accepted it, even if he later took it back. One real case from this era involved a railroad worker accused of murder after a violent fight near a train yard. Witnesses claimed they saw him running from the scene. The trial lasted only days. His lawyer barely spoke. The jury returned a guilty verdict before sunset.
The man said he was innocent. No appeal was allowed. Weeks later, another worker came forward and admitted he had lied to protect himself. He said he had been drunk, confused, afraid, but the court refused to reopen the case. The execution went ahead as planned. Stories like this were not rare, they were common. Prisons across America held men waiting to die, knowing their fate was sealed not by truth, but by speed. In states like Pennsylvania, Ohio, and New York, executions were scheduled quickly to avoid public unrest. The faster the punishment, the calmer the public. Justice was not about certainty, it was about control. For poor prisoners, the system was especially cruel. Wealthy defendants sometimes delayed execution through legal connections. Poor men could not. Immigrants suffered even more. Many did not understand the court process. Some did not even understand the language spoken at their trial. Yet the verdict was still read: guilty, death. In many prisons, condemned inmates were moved to special cells near the execution area. Guards avoided them. Other prisoners whispered about them. Some believed the condemned carried bad luck. Others feared they might lose their minds before the end. There were no counselors, no religious comfort unless the prisoner asked. Nights were long. Sleep was rare. Some men wrote letters. Others stared at the wall. A few prayed for a miracle that rarely came. The law did not require proof beyond all doubt. It required a decision. And once that decision was made, the system refused to look again. But cracks were forming. Newspapers began printing stories about questionable convictions. Journalists visited prisons and spoke with condemned men. Some reported stories that did not add up, witnesses who disappeared, evidence that was never shown to the jury. Public trust began to shake. One famous example came from Massachusetts, where a young immigrant laborer was convicted of murder based on shaky testimony. After his conviction, multiple people came forward with information that supported his innocence. Even a juror admitted doubts. Still, the execution date remained. The governor refused to intervene. The man was executed. Years later, historians would agree the case was deeply flawed, but by then, it was too late. The system did not correct itself. It buried its mistakes. Executions were often carried out quietly to avoid protest. In some states, executions moved inside prison walls instead of public squares. Officials believed secrecy would protect the image of justice, but secrecy also hid errors. Families of the condemned were rarely informed in advance. Some learned of the execution days later. They were given bodies without explanations. Records were sealed. Questions went unanswered. For the condemned, the worst part was not the method of execution. It was knowing no one would listen. Men cried out innocence until their final breath. Others accepted death simply because fighting felt useless. When hope disappears, silence follows. Inside one prison, a guard later wrote that condemned men often became calm in their final days, not because they accepted guilt, but because they accepted defeat. The law had spoken.
And the law did not care if it was wrong. As the 1890s approached, the electric chair was introduced as a modern solution. Officials claimed it was cleaner, faster, more civilized. But the heart of the problem remained unchanged. There was still no appeal. Mistakes still moved forward, and death still came on schedule. Some reformers began pushing back. Lawyers argued that justice required review, that one trial was not enough to decide life and death. They pointed to cases where evidence appeared after conviction. The system resisted. Admitting error meant admitting failure, and failure was unacceptable. But something was about to happen that would force America to look at its death row system in a new way. A case so troubling, so impossible to ignore, that even the strongest defenders of the old system would feel uneasy. It would involve a confession that unraveled, a witness who disappeared, and a truth that surfaced when it could no longer save a life. The cell door creaked open. The guard stepped inside, and the man looked up, hoping for words that never came, because the execution was still set, and the truth was still running out of time. The next chapter begins when America is forced to ask a dangerous question. What happens when the law kills the wrong person and cannot take it back? The execution was over before the sun fully rose. Inside the prison yard, the witnesses stood still. No one spoke. The body was removed quietly, just as the law demanded. Papers were signed. A time of death was written down. Another case was closed. But this time, something followed the execution. A confession. It came days later, then weeks later, then again years later, spoken in whispers and written in letters. A man, dying from illness in another state, admitted that he had committed the crime. He named details only the real killer could know. He described the scene exactly as it had been found. The man who had been executed was innocent, and America could do nothing about it. This was the moment that changed everything. In the late 1800s, stories like this began to spread. Not just one, not just two, but many. Wrong men executed, truth discovered too late, families destroyed forever. The justice system had no way to fix its worst mistakes. Death row before 1900 was built on speed, not certainty. The belief was simple. A fast punishment stopped crime. A public execution scared others into obedience. Appeals were seen as weakness. Mercy was seen as danger. But the bodies kept piling up, and the doubts kept growing. Newspapers began publishing full stories, not just short crime notes. Reporters dug into old trials. They reread testimony. They found missing witnesses. They exposed rushed verdicts. Some stories shocked the nation. One article asked a question that made judges uncomfortable. How many innocent people have we already killed? The answer was unknown. Records were incomplete. Files were lost. Some executions were barely documented. In rural areas, hangings happened with little paperwork at all. Once the rope fell, history often stopped recording. Families of the executed lived in silence. Speaking out was dangerous. Questioning the courts could bring shame or punishment. Many families moved away, carrying the truth with them. But the fear began to fade. By the 1890s, lawyers and reformers started pushing harder. They argued that human systems make mistakes, that one trial cannot decide life and death forever, that appeals were not delays, but protection. Some judges listened, others did not. Inside prisons, guards noticed changes too. Condemned inmates became symbols of unease. Some guards refused to participate in executions. Others drank heavily afterward. A few quit their jobs. Killing in the name of justice had a cost. The electric chair, once praised as progress, became another source of horror. Early executions went wrong. Prisoners suffered longer than expected. Witnesses fainted. Doctors argued over results. If the method was flawed, people asked, what about the conviction? In one case, a man executed by electricity was later linked to new evidence proving his innocence. The chair had worked perfectly. The justice had not. Slowly, very slowly, the system began to crack. Some states introduced limited reviews. Governors granted rare pardons. Courts began discussing appeal rights. These changes did not bring back the dead, but they stopped some future executions. Too late for many.
By the time the 20th century arrived, America could no longer ignore what it had done. Death row without appeal had created a legacy of doubt. Every execution carried a question mark. Every verdict carried fear. Had the right man been punished, or had the system moved too fast again? The past could not be erased, but it could be remembered. And remembering was dangerous, because remembering meant admitting that justice had failed. The men executed before 1900 never got appeals, never got second chances, never got to hear the words, "We were wrong." Their punishment was final, their silence permanent, but their stories changed the law. Modern appeals, review courts, innocence claims, all were born from the blood and mistakes of the past. Every safeguard that exists today was paid for by someone who never lived to see it. And even now, that question still follows every execution. What if we are wrong? The rope no longer hangs in public squares. The chair is rarely used. The process is slower, more careful. But the shadow of those early deaths remains. Because once the state takes a life, there is no appeal that can fix it. And that is the lesson America learned too late.
But the story does not end here, because the fight over death row did not stop in 1900. It only changed shape. And in the next chapter, the past returns to challenge the present in ways no one expected. As we continue, you'll see just how fast the law moved back then, and how mistakes could mean the difference between life and death. You'll meet men who were condemned on weak evidence, families left in despair, and the journalists who tried to expose the truth too late. If you find this story shocking, make sure to hit the like button and comment below what you think about punishment without appeal. And don't forget to subscribe, because every week we uncover real, true crime stories from America's past that are stranger than fiction. The courtroom was silent when the judge spoke. No rope, no chair, no crowd outside. Just a stack of old papers on a wooden desk, and a question that had waited more than 100 years to be asked. Was this execution a mistake? The man had been dead since the 1890s. His grave was unmarked. His family line had ended in shame and fear. Yet now, long after his death, the state was finally looking back at his case. This was something that never happened before 1900, and it was happening because the past refused to stay buried. The moment felt strange and heavy, not because the man could be saved, he could not, but because the system was being forced to face what it once refused to admit, that punishment without appeal had consequences, and they never disappeared. As the 20th century began, America tried to move forward. New laws were written. Appeals slowly became part of the justice system. Courts began to review old ideas about guilt and fairness. But death row before 1900 remained a dark shadow behind every change. Each reform was a quiet confession. We were wrong before. In the early 1900s, lawyers started reopening old cases, not to free prisoners, but to understand how justice failed. They found trials that lasted only hours, juries chosen in minutes, judges who pushed verdicts forward to calm angry crowds. In many of these cases, the accused never stood a real chance. One man had been convicted because he was the last person seen near the crime scene. Another because he fit a description given at night by a frightened witness. Another because he refused to confess, and silence was taken as guilt.
All were sentenced to death. None were given appeals. The system believed certainty mattered more than truth. But truth does not disappear just because the law ignores it. Families of the executed began speaking out, quietly at first, then louder. Grandchildren asked questions. Old letters were discovered. Prison records were examined. Some families learned their ancestor had never even had a lawyer. Others learned witnesses had been paid. The past started to speak. Historians uncovered execution logs showing how fast the system moved. In some states, less than 30 days passed between conviction and death. There was no time for doubt, no time for review, no time for mercy. It was justice on a schedule. And once that schedule started, nothing stopped it. The idea of appeal now feels normal, but before 1900, appeal was seen as dangerous. Courts feared it would weaken authority, that criminals would escape punishment, that order would collapse. So instead, the system chose finality. Finality feels strong, until it is wrong. Every execution without appeal created a permanent wound, not just for families, but for the law itself. Because once innocence became possible, certainty became a lie. By the mid-1900s, America had changed. Appeals became standard. Death sentences were reviewed again and again. The process slowed. Safeguards were added. But the question never went away. If we killed the wrong people before, how can we be sure we do not do it again? The men executed before 1900 never got that protection. They became lessons written in blood. Their stories shaped every argument against rush justice. Every time a modern execution is delayed, their ghosts stand in the background, waiting, watching, and reminding.
Some states began clearing names posthumously, not to undo death, but to admit failure. These moments were quiet. No headlines, no celebrations, just paperwork and apologies that came too late. But even that was powerful. It meant the system was finally willing to say something it never said before. We were wrong. Yet many cases remain untouched. Thousands of executions before 1900 were never reviewed. Their stories are lost, their names forgotten, their innocence or guilt unknown forever. They remain trapped in history. Punishment without appeal did not just end lives, it ended truth. And once truth is gone, justice becomes an illusion. Today, when people argue about the death penalty, they often look to science, evidence, technology, DNA. But long before any of that existed, people were already warning about speed and certainty. They were ignored because fear spoke louder. The past teaches us something simple and frightening. A system that refuses to look back will always repeat its worst mistakes. Death row before 1900 was not just cruel, it was careless. And carelessness with life is the most dangerous crime of all. The judge in the modern courtroom closed the file. There was no punishment to undo, no sentence to reverse, only a record to correct. Outside, the sun set quietly. No crowd watched, no rope hung, but the weight of history remained. Because once the state kills without appeal, the damage lasts longer than any sentence, and the question still stands. If justice once moved faster than truth, how do we know it never will again? This story ends here, but the debate does not. And somewhere, deep in old prison records, more names are still waiting to be heard. The record book snapped shut with a sharp sound. Dust lifted into the air as the clerk slid it back onto the shelf. Another name sealed inside, another life reduced to ink and silence. For more than a century, these books sat untouched, holding the final words of men who were never allowed to fight back. This chapter begins with what those books never said out loud. They never said the word innocent. In the years after 1900, America tried to convince itself that the worst days of justice were over. Appeals existed now, courts moved slower, laws sounded fairer, but the past refused to stay quiet. The truth was simple and terrifying. Everything that changed was built on people who never lived to see it. Death row before 1900 did not end because the system suddenly grew kind. It ended because the system could no longer hide its mistakes. Too many questions, too many doubts, too many lives taken without review. And still, those early executions continued to shape every decision that came after. Judges remembered them, lawyers studied them, law students were warned about them. They became lessons taught in whispers. Do not rush. Do not assume. Do not close the door too fast. Because once it closes, there is no reopening it. In many states, reforms came slowly. Some allowed limited appeals. Others only allowed review if the governor approved it. Even then, it was rare, but rare was better than never.
The idea that a man deserved more than one chance to prove his innocence was once radical. Before 1900, it was unthinkable. The men executed in that era became shadows in the law. Their cases were cited in debates, their mistakes used as warnings. Every safeguard added later carried their silent fingerprints. The right to appeal, the right to new evidence, the right to question witnesses again. All of it existed because punishment without appeal went too far. Yet something darker remained. The system never truly counted its dead.
No official number exists for how many innocent people were executed before appeals became common. Some estimates suggest dozens, others suggest hundreds. The truth is unknown, because the system did not want to know. To admit the number would mean admitting failure on a massive scale. So the records stayed quiet, but families did not forget. Stories passed down through generations. A great-grandfather who died too fast, a name spoken with sadness, a crime that never made sense. Children grew up knowing something was wrong, even if they did not know why. In some families, fear replaced anger. They stopped asking questions. They stopped trusting the law. Silence became survival. That silence lasted decades, until people began asking again. In the late 19th century, historians and legal scholars returned to old execution cases. They found missing transcripts, lost evidence, trials that ended before they should have begun. They found men sentenced to die without ever calling a witness. They found verdicts reached before the defense even stood. They found justice moving like a machine that could not stop itself. And they found something else: patterns. The same kinds of people were punished fastest: the poor, the uneducated, the immigrant, the unwanted. The system did not say it out loud, but its actions spoke clearly. Speed was not applied equally. Mercy was not shared evenly. Before 1900, death row did not care who you were, but it cared very much what you had. Money bought time. Time bought life. Without time, innocence meant nothing. That lesson still echoes today. Every time a modern court delays an execution, someone complains that justice is too slow. But slow justice exists because fast justice once killed the wrong people. Every pause is paid for by someone who never got one. And still, even with appeals, the fear remains. Because punishment without appeal is not just a legal failure, it is a human one. It assumes perfection where none exists. It assumes certainty where doubt lives. It assumes truth always wins the first time. History proves it does not. The men executed before 1900 were trapped in a system that feared looking weak more than it feared being wrong. A system that valued finality over fairness. Their deaths ended quickly. Their consequences did not. Even now, when courts argue over life and death, the past stands nearby, invisible but present, asking the same question it asked more than a century ago. What if we are wrong? That question has no comfortable answer, because once a life is taken, no court can return it. No apology can fix it. No appeal can undo it. Punishment without appeal leaves no room for truth to arrive late, and truth often arrives late. That is the lesson written across America's early death rows, a lesson learned through loss rather than wisdom, through silence rather than courage. This chapter ends where those men began, in a cell, alone, waiting, not for justice, but for time to end. And as long as the death penalty exists, their warning still matters. Slow down, look again, because once the door closes, it never opens the same way twice. The final bell tolled inside the prison tower. It marked the hour when another life would soon end. Yet this time, the crowd outside was gone, the execution private. The condemned man sat in silence, staring at the blank wall of his cell. He knew what history had already taught. Once a sentence was handed down, there was no escape, no appeal, no second chance. In America, before 1900, death row was the absolute end.
This chapter begins with the harsh truth that haunted every prison across the nation. A system built for speed over fairness left little room for doubt. Men were executed in a matter of days or weeks, often on weak or circumstantial evidence. Sometimes a single witness's word was enough. Confessions, coerced or misunderstood, were treated as facts. And once a judge said, "guilty," the machinery of death moved forward relentlessly.
Families were left powerless, and innocents rarely had a voice. Across New York, Pennsylvania, Georgia, and Texas, this system operated like clockwork. Executioners followed instructions, guards carried out orders without question. Clerks documented each death in neat handwriting, unaware that those pages would one day become grim historical records. Each line represented a person whose life ended before their story could be fully told. Yet, even in this darkness, the seeds of change had begun. Reformers, journalists, and lawyers gradually shone a light on the injustices. They documented wrongful convictions, examined rushed trials, and questioned the fairness of a system that refused to pause for truth. Their efforts eventually created the appeals processes and review systems we rely on today. But for the men who lived and died before these protections, it was too late. Their lives were gone, their voices silenced forever. The consequences of punishment without appeal were not just personal, they were societal. Entire communities learned to fear the courts. Families distrusted the law. Public faith wavered, and the shadows of doubt stretched far beyond the prison walls. Every execution carried a silent warning. Certainty in judgment is dangerous when human error exists. By the end of the 19th century, America had begun to see that the law, when untempered by review, could be deadly and irreversible. Every executed prisoner served as a grim testament to the price of speed over justice. Their deaths taught the nation that a single mistake could never be undone, and that truth, delayed or ignored, offered no protection to the innocent. As the prison bell fell silent one last time, the lesson remained clear. Punishment without appeal is final. History remembers these men not just as statistics, but as warnings. Their stories, recorded in faint ink and fading memories, continue to shape the justice system today. Every appeal court, every review board, every careful step in modern sentencing exists because the mistakes of early death row demanded it. And while the executions of the past cannot be undone, their echoes remain, a permanent reminder that when justice moves too fast, lives are lost, and history never forgets. This story may have ended over a century ago, but its lessons are still alive today. The men on death row before 1900 didn't get a second chance, and their silence shaped every modern appeal and review system. If you want more gripping stories like this, real events, shocking truths, and crimes that history almost forgot, subscribe now and hit the notification bell so you never miss a story. Every week, we bring you the darkest corners of America's past, stories you won't hear anywhere else. Remember, justice may move slowly today, but the past reminds us of what happens when it moves too fast. Don't miss our next true crime documentary.